The easiest way for you to lose your kids' inheritance is by not having an estate plan. Whether you have real estate, investment accounts, or retirement assets, without documents that address what happens to your assets in the event of your incapacity or death, you may be surprised by who winds up with your assets. You may find that you need to go to probate court to get them to your people. That's a long and expensive process, sometimes taking a year or more. You may find that your son's soon-to-be ex-wife has rights to money you thought you were leaving to him. You may find a child you thought disinherited will actually inherit your home with the rest of your children. You may find that your new spouse gets everything, leaving your kids out altogether. Over the next few minutes, I'm going to share with you how you may protect assets you own and the people you love, assuring your wishes are carried out the way you want. I'm Barbara Pizzolato, and I help people manage the rest of their continued living. And in every single video, I'll help you understand how you may protect your assets and your family navigate difficult situations that can arise during incapacity or death. For most people who own a home and significant investable assets, but not a federally taxable estate, they believe owning their assets with their spouse jointly is all the estate planning they need. Nothing could be further from the truth. Tax laws change all the time. In fact, our latest federal estate tax law will sunset January 1st, 2026. In addition, incapacity can occur at any time. How many of your friends have suffered a stroke or been debilitated in a car accident? Or if you and your spouse were in a car accident resulting in your death and your spouse's incapacity, would someone have access to your assets for your spouse's benefit? Would it surprise you to know that many financial institutions refuse to accept powers of attorney? That's assuming you even have one. If someone has incapacity and does not have the proper documents, a guardianship proceeding must be commenced to appoint someone to act on behalf of the incapacitated person. Guardianship proceedings can be very expensive and time-consuming, and a stranger will be appointed to manage your affairs. Yes, a stranger, someone you have no connection with, could be managing your affairs for you. Many people believe a simple will and a power of attorney is all they need for an estate plan. However, a will is only good if you drop dead. A revocable trust, on the other hand, is the premium estate planning tool. The revocable trust keeps you in control for as long as you are not wiggly in the head and are on this side of the grass. And when you do become wiggly, the person you have chosen to succeed you will become your successor trustee and will manage your assets for your benefit until your death, distributing your assets after your death to the people and charities you instructed in your trust document. Every lending institution will happily deal with your successor trustee because the bank risks no liability. With a revocable trust, it is business as usual. Here's the bottom line. The revocable trust allows you to protect the people you love and the assets you own.